I finally brought my pride and joy back home after a grueling 6 months of international litigation. A towering, mud-splattered, jet-black monster truck that I affectionately call Objection Sustained. But the moment I turned the key to silence the roaring beast, a brittle, tri-fold letter was already taped to my front door, an urgent notice from the Homeowners Association that read like a final warning, even though it was the first time we had ever crossed paths. Apparently, my monster truck violated nearly every clause they had about aesthetic uniformity, visual pollution, and vehicular harmony, phrases I had never seen used outside of satirical legal textbooks. The letter, signed aggressively in red ink, claimed that if I didn't remove the truck from my driveway within 48 hours, they would initiate legal proceedings, issue fines exceeding $10,000, and escalate to property liens if necessary. That alone would have been enough to annoy me, but it was the handwritten postscript that really caught my attention, reading, "We are aware of your profession. Don't try to lawyer your way out of this." That was the moment I knew the HOA had picked the wrong fight, because not only am I a lawyer, but I am a litigator feared across 3 continents, a courtroom juggernaut who has taken down tech giants, pharmaceutical empires, and even governments for sport. Ironically, this driveway dispute was the smallest case I'd ever touched, but something about the arrogant tone of that letter made it personal. I walked up and down my driveway staring at Objection Sustained, thinking about all the miles we'd traveled, all the impossible terrains we'd conquered together, from Chilean salt flats to Icelandic glaciers. And now, a suburban neighborhood committee wanted to declare my truck illegal because it didn't match the cookie-cutter sedans lining the cul-de-sac. I spent the rest of the evening combing through the HOA's governing documents, and what I found only added fuel to the fire. Their vehicle appearance code had language so outdated, it still referenced fax machines and VCRs. It described acceptable vehicles as conservative personal conveyances no taller than 6.5 feet and painted in neutral tones. Objection Sustained, standing proud at 12 feet 4 inches, with shocks that could clear a small boulder and tires that belonged in a monster truck rally, wasn't just non-compliant, it was a declaration of war against their bland suburban vision. The next morning, before I even had my coffee, the HOA president herself stood at my door, flanked by 2 board members clutching clipboards like weapons. They didn't greet me, they just pointed at my truck like it was a crime scene. "Remove it," the president said, her voice trembling with the conviction of someone who had never been told no before. I smiled because there's nothing I love more than telling people like her no, especially when I know the law is on my side. "Under what specific clause?" I asked, knowing full well their bylaws were about as legally airtight as a rusty screen door in a hurricane. She stammered out something about visual consistency and neighborhood harmony, and I nearly laughed because that's subjective drivel no judge would ever enforce. But I didn't laugh. I took their demands seriously, because I knew the more seriously I took them, the more fun it would be to crush them in court later. As they left, they warned me that every hour the truck stayed in the driveway would accrue fines, escalating from hundreds to thousands within days. I let them leave, fully intending to let those fines pile up like evidence in my eventual countersuit. Over the next few days, I documented everything. Every email, every passive-aggressive note slipped under my door, every neighborly glare from behind half-closed blinds. The HOA even went so far as to Photoshop images of my truck to make it look larger and more menacing in their newsletters. They called it a threat to property values, comparing it to an industrial accident parked in front of a family home. But what they didn't realize was that every ridiculous claim they made was another nail in their legal coffin. You see, while I may have been a lawyer who specialized in high-profile corporate takedowns, I cut my teeth on cases just like this: local governance overreach, HOA power abuse, and property rights violations. By the end of the first week, I wasn't just fighting for my truck. I was fighting for every homeowner who had ever been bullied into submission by a petty suburban regime with too much free time and not enough real power. I reviewed zoning laws, vehicular rights statutes, and even a 1956 municipal code that guaranteed driveway autonomy after a famous case involving a firetruck collector. When the HOA issued their final warning, giving me 24 hours to comply before they sent a tow truck, I issued my own warning, a cease and desist letter drafted with the precision of a nuclear warhead. The document laid out 37 individual legal violations they had already committed, from procedural defects to civil rights infringements. I couriered the letter to each board member's house at midnight because I wanted it to be the first thing they saw when they opened their doors. The next morning, their tone had shifted from aggressive authority to nervous diplomacy. But by then it was too late. This wasn't about diplomacy anymore. It was about victory. The day after my midnight cease and desist delivery, I expected silence from the HOA board, maybe a timid request for a meeting or a desperate attempt at mediation. Instead, I woke up to a certified letter shoved halfway through my mail slot, folded so aggressively that the paper tore down the middle. The letter informed me that the HOA had voted, in what they described as an emergency executive session, to file an immediate civil suit against me in county court. They accused me of violating community standards, defying lawful orders from the governing body, and engaging in what they called intentional aesthetic sabotage. That last phrase made me laugh out loud because it sounded like something cooked up by a teenager taking their first mock trial class. I knew instantly that this case would never survive the first procedural hearing, but that was not the point. This was no longer just about my monster truck. It was about control, about reminding me and everyone else in the neighborhood that the HOA held the leash, and they were willing to drag anyone through the mud who dared to pull back. They did not know that I was born in the mud, both figuratively and literally, having grown up on the unpaved backroads of Mississippi where monster trucks were not hobbies, they were survival tools. I spent that entire afternoon assembling my first legal salvo, a blistering motion to dismiss that outlined every legal error they made in their rushed filing. They failed to properly notify me of their intent to sue, violating both the HOA charter and basic civil procedure. They misquoted their own bylaws, incorrectly citing a 2007 amendment that was overturned by a 2012 referendum. And my personal favorite, they filed in the wrong court entirely, submitting to a small claims docket that lacked jurisdiction over property disputes of this magnitude. Before I filed the motion, I printed 2 extra copies and taped them to the HOA bulletin board by the community pool, right next to their laminated list of approved grass heights and mailbox colors. But I was not naive enough to think the fight would end there. In fact, I hoped it would not, because I was having too much fun watching them unravel. The HOA responded not with logic or law, but with petty public relations warfare. They printed flyers showing doctored images of my truck crashing through neighborhood fences and sent them to every resident's mailbox. They circulated anonymous complaints claiming I was hosting illegal vehicle rallies in my driveway, all because I had once invited a few friends over to admire the custom suspension work. They even tried to get the local police involved, reporting my truck as an abandoned commercial vehicle, hoping it would be towed before the case even reached a judge. Unfortunately for them, the local police knew me very well. I had represented half their department pro bono after a messy wrongful termination scandal the year before. Not only did they refuse to tow my truck, but 2 officers stopped by just to take selfies with it. Every petty attack the HOA launched only made my countersuit stronger. I expanded my claims to include defamation, harassment, and abuse of process, each count supported by reams of evidence they had so graciously handed me in their own attempts to intimidate me. Neighbors began to take sides, and to the board's horror, most of them sided with me. Some had their own horror stories of being fined for absurd reasons. A garden gnome too whimsical, a porch swing too colorful, Christmas lights that stayed up one day past the deadline. My fight became their fight, and by the end of the week, my driveway had become a local landmark, with parents bringing their kids by to take pictures with the infamous monster truck the HOA could not defeat. The case itself became a public spectacle, covered by the local news and even picked up by a regional legal blog that labeled it the most ridiculous abuse of HOA power they had seen in years. By the time we arrived for the first court hearing, the courtroom was packed with reporters, curious residents, and even a handful of law students eager to see what happens when a world-class litigator goes head-to-head with a suburban homeowners association. I walked into court wearing a tie patterned with tiny monster trucks, which I made sure to adjust dramatically every time the HOA attorney looked my way. They had hired a local real estate lawyer who specialized in zoning variances and easement disputes, a perfectly competent professional, but entirely unprepared for the full-scale litigation war I was about to unleash. Before opening arguments even began, I filed a motion for sanctions, citing the HOA's deliberate misuse of judicial resources and their pattern of malicious behavior. The judge, already unimpressed by the amateur hour filing errors, granted my motion to consider sanctions pending the outcome of the case. That meant even if the court ruled against me, the HOA could still be on the hook for my legal fees and damages if I proved their conduct was abusive. The HOA attorney paled visibly, and I knew right then that I had already won this case in everything but paperwork. But I was not content with just winning. I wanted to make this case a permanent stain on the HOA's record, something future homeowners could point to whenever the board tried to flex their tiny muscles over some arbitrary rule. This was not just about parking a monster truck anymore. This was about principle. And I never lose when principle is on the line. The courtroom was supposed to be a battleground over my monster truck, but by the second day of hearings, it had morphed into something far stranger, something personal, something much deeper than vehicle dimensions or driveway aesthetics. The HOA's attorney opened with a dry recitation of bylaws and a half-hearted attempt to paint me as a disruptive influence, but they barely made it through their first argument before I pounced. I presented my first exhibit, an internal HOA email chain I had obtained through discovery, where board members openly mocked residents for trivial violations and laughed about slapping homeowners with arbitrary fines just to remind them who was in charge. My personal favorite was an email from the president herself, describing the neighborhood as her personal fiefdom and comparing her role to a medieval queen keeping the peasants in line. That was the moment the case flipped from property dispute to a referendum on the HOA itself. Residents who had once been too scared to speak out started showing up in court, bringing their own stories of harassment, fines for imaginary infractions, and threats to revoke pool access over issues as petty as mismatched patio furniture. What had started as my personal legal grudge match was turning into a full-scale neighborhood rebellion, and I was more than happy to lead the charge. As my witnesses took the stand, it became painfully clear that the HOA had operated less like a governing body and more like a schoolyard clique, playing favorites with compliant homeowners while punishing anyone who dared question their authority. One elderly couple testified that they had been fined $500 for having an American flag displayed on their porch after Memorial Day, a violation that existed nowhere in the bylaws but was invented on the spot because the couple had once filed a noise complaint about a board member's loud 4th of July party. Another homeowner explained how he was forced to repaint his house twice in 1 year because the board kept changing the definition of acceptable color palettes, all because his teenage son had accidentally dented the HOA treasurer's car with a basketball. The judge's face went from mildly irritated to deeply disturbed as the stories piled up, turning my case into something far more damning than a simple parking dispute. But the real turning point came when I called my surprise witness, an HOA whistleblower who had quietly fed me internal documents, recordings of closed-door meetings, and even draft versions of the very letter they had taped to my door. The whistleblower turned out to be the HOA secretary, a woman who had grown tired of the board's power games and who admitted under oath that they had deliberately targeted me not because of my truck, but because they were afraid of having a high-profile attorney living in the neighborhood who might uncover their dirty laundry. According to her testimony, the monster truck was just the pretext. The real goal was to force me out before I could become a permanent thorn in their side. That was all I needed to hear. I shifted my legal strategy on the spot, expanding my countersuit into a full-blown civil rights case, arguing that the HOA had engaged in targeted harassment, selective enforcement, and retaliation against me for my profession and my willingness to stand up to them. My opening statement had been about a truck. My closing argument was about freedom, the freedom to live without fear of arbitrary punishment, the freedom to own a vehicle that expresses your personality, the freedom to barbecue in your driveway without getting a citation because your grill is the wrong shade of gray. By the time I finished, the courtroom felt less like a legal proceeding and more like a town hall meeting where the people had finally decided to take back control from their self-appointed overlords. And then came the twist I never expected. As we recessed for lunch, a man approached me outside the courthouse, a man I recognized but could not quite place until he introduced himself. He was the founder of the HOA, the man who had drafted the original charter back when the neighborhood was first built in the late 90s. He told me that the HOA had not started out this way. It had been meant to protect property values, yes, but also to foster a sense of community, to help neighbors resolve disputes peacefully, and to create a place where families felt safe and supported. He had resigned years ago when the current board took over, disgusted by their obsession with power and control. And then he handed me something I could hardly believe, a notarized amendment to the original charter, one that had mysteriously gone missing from the HOA's official records. This amendment limited the HOA's power to enforce aesthetic rules on vehicles parked in personal driveways, specifically protecting larger vehicles used for work, recreation, or personal expression. It was legally binding, still valid, and had been deliberately suppressed by the board because it contradicted their endless pursuit of uniformity. Armed with this amendment, my case shifted from strong to ironclad. The HOA had not just harassed me, they had violated their own founding documents to do it. And now, thanks to their former founder, I had the proof in my hands. When court resumed, I introduced the amendment into evidence, watching the color drain from the HOA president's face as the judge read it aloud. It was a direct, undeniable checkmate. But even as victory was all but certain, I knew this fight had become about more than winning in court. It was about breaking the culture of fear that the HOA had cultivated for years, about showing the neighborhood that they were not powerless, that one person with the right knowledge and enough stubbornness could stand up to the machine and win. By the end of that day, half the neighborhood was sitting in the gallery, cheering me on like I was fighting a championship match instead of a legal dispute. And for the first time in my career, I felt like I was not just practicing law. I was doing something that mattered on a human level. This was no longer about objection sustained. This was about justice. The day the verdict was announced, the courtroom was so packed they had to open the overflow room. Reporters were squeezed shoulder to shoulder with residents, some of whom had been fined so many times by the HOA that they brought folders of their own receipts, just in case anyone wanted to see proof of what they had endured. The judge took her seat with a look that was half exhaustion, half grim satisfaction, the expression of someone who had spent weeks sorting through mountains of evidence for a case that had started as a petty parking dispute and grown into a full-scale expose of suburban tyranny. In her ruling, she did not hold back. She found the HOA guilty on every count of harassment, selective enforcement, defamation, and abuse of process. She ruled that they had violated their own governing documents, breached their fiduciary duty to the homeowners they were supposed to represent, and engaged in conduct so outrageous that she referred parts of the case to the state's attorney general for further investigation. She imposed the maximum allowable fines, ordered the immediate suspension of the entire board pending new elections, and, most satisfying of all, ruled that the HOA would have to cover all my legal fees, which by then had grown to a sum larger than the association's entire annual budget. But even that was not the real victory. The real victory came when the judge addressed the homeowners directly, telling them in no uncertain terms that they had the power to reshape their HOA, to rewrite the bylaws, to elect leaders who actually represented their interests instead of ruling through intimidation. By the time court adjourned, the neighborhood felt like it was on the edge of revolution. Residents gathered outside in the parking lot, swapping stories about their own battles with the HOA, hugging each other, some even crying from relief that the reign of petty terror was finally over. And through it all, my monster truck stood parked right in front of the courthouse, gleaming in the afternoon sun, the same truck they had once called a visual blight now transformed into a symbol of defiance and victory. The HOA president resigned before she could be formally removed, slinking out of the courthouse through a side door, refusing to answer questions from the press. But the rest of the board was not so lucky. Over the next month, they were subjected to a full forensic audit, revealing years of financial mismanagement, improperly collected fines, and even a few shady contracts with landscaping companies owned by relatives of board members. The new interim board, elected within weeks, included several of the very homeowners the old board had targeted, people who had been fined for things as ridiculous as leaving their recycling bins out an hour too long or using the wrong type of mulch. One of the first actions the new board took was to repeal the vehicle appearance code entirely, replacing it with a simple rule: if your vehicle fits in your driveway, it is allowed. No height limits, no color restrictions, no aesthetic guidelines invented by power-hungry suburban dictators. They even drafted a resolution officially declaring my monster truck an honorary community landmark, a tongue-in-cheek gesture that made the local news and cemented Objection Sustained's place in neighborhood history. But the fallout did not stop at the neighborhood's borders. The case went viral, spreading across social media, drawing attention from legal reform advocates, property rights groups, even a few celebrity lawyers who invited me onto their podcasts to tell the story. My inbox overflowed with messages from homeowners across the country sharing their own horror stories about overzealous HOAs, begging for advice, asking if I would take on their cases. I could have turned it into a second career if I wanted to, but in truth, this case had reminded me why I became a lawyer in the first place. It was not for the corporate battles or the million-dollar settlements. It was for moments like this, standing up for the little guy, using the law not as a weapon for the powerful but as a shield for the ordinary. In the weeks that followed, I became something of a neighborhood folk hero, invited to every block party, every barbecue, even asked to officiate a backyard wedding for a couple whose only connection to me was that they had once been fined for having a birdhouse shaped like a pirate ship. And through it all, Objection Sustained remained right where it belonged, parked proudly in my driveway, a daily reminder that sometimes, the biggest fights come from the smallest sparks. The HOA had tried to make me a cautionary tale, but instead, they made me a legend. And every time I fired up that engine, shaking windows and rattling nerves, I smiled knowing that no matter how much power they thought they had, in the end the law was always louder.